We are going to get started in just a few moments. We're letting folks get logged in. So we will start promptly at 1 o'clock. I have an ask of you as we're getting started. I would love to know if this is your first time attending a webinar with us at ILSAA. If so, would you put your name and your location in the chat? Like, what state are you from? We would love to know that. So just, or even if you're returning, put your name in the chat. And if you if you've been here before, you can just let us know you're returning. With Maryland, Arizona, New York, New Jersey, Tulsa, nice. Ohio, oh, lots of folks. I wish I had the map today. Sometimes we have a map up there. It would be fun to see a map of where we have folks. Des Moines, Iowa, yay for Iowa, fellow Midwesterner. All right. Well, we are going to go ahead and we are going to start right at 1 o'clock, or 1 o'clock Eastern. So let me welcome you all officially to our ILSAA. ILSAA stands for Immigration Legal Services for Afghan Arrivals. Welcome to our webinar. Our topic this month is After Asylum is Granted, Adjustment of Status for Afghan Asylees. We have a full hour for you today. The topics that we're going to cover, I'm going to ask you, you can go ahead and flip to slide 3 if you don't mind. The topics we're going to cover today is a little bit of background on adjustment of status, special considerations for Afghan asylees. We'll go through a process overview, key information around applying, after applying, adjustment of status decisioning, and most importantly, we will have time. We're going to walk through a couple of scenarios and give time for questions and answers. So welcome everyone. Again, if you're just dialing in, if you are new to an ILSAA webinar, if you would please put your name and what state you're from in the chat as we get started. And Hannah, if you would flip back to slide 2, just a couple of things I want to cover as we get started. We are recording the webinar today. We want this to be available after the session. You will get a link to today's recorded webinar after the session. So you can share it with your friends and peers if they didn't have the chance to be here today. It will be an interactive webinar today. We ask that you please save your questions towards the end if you don't mind. So write them down if you're like me and can't remember. We'll ask for questions towards the end of the webinar and get to as many as we can. If you do have any technical issues, you can send a private message in the chat to Bridget Ott. She's in the meeting today, and we will do our best to assist you. Most importantly, at the end of today's session, at the end, you will get an evaluation link. We want to hear your feedback on the session, and that will come along with the materials and resources from today's session. So with that, let's go on, and I will introduce your speakers. Again, my name is Becky Blenderman. I work in ILSAA, and I want to introduce our speakers for today. You can go ahead to the next slide 4 there, Hannah. And introduce the 2 speakers I want to introduce. Let me see if we can. There we go. Thank you, Hannah. We have 2 presenters, both from ABA, Stephanie Baez and Stacy Kim. And to begin our presentation today, I will turn it over to Stephanie. You want to introduce yourself and get rolling?
All right, great. Thank you so much, Becky. Thanks for having us here today. And thank you for everyone for joining us for this presentation. As Becky mentioned, my name is Stephanie Baez, and I am the Director of Pro Bono for the American Bar Association Commission on Immigration. And Stacy and I are both with the Commission on Immigration and are happy to be here today. At the Commission on Immigration, we've been working in the Afghan space for the past couple of years, and we are very happy to be partnered with ILSAA to provide some subject matter expertise on topics related to representing Afghans in immigration matters. So today we are going to cover adjustment of status. And before we jump into that, I just want to give a quick background to make sure we're all on the same page for why this topic is so important. As you probably know, in August of 2021, the Taliban took over in Kabul, Afghanistan, after 20 years of US occupation there. And when that takeover occurred, an estimated 1.6 million Afghans fled from their homes, and approximately 88,500 Afghans came to the United States. For that group that came to the United States, there's no automatic path to permanent status in the US. And so many of those people were paroled into the US, meaning that they were given a temporary legal status to live and work here, but parole is temporary. So to have a permanent status, people need to apply for something else. And many people from that group have applied for asylum or for a special immigrant visa. Those are two of the common paths towards requesting permanent status in the United States. The other types of status that you might hear talk about are parole, which is now moving into re-parole as that's being extended. But like I said, that's a temporary status that only lasts for 2 years at a time. And there's also temporary protected status, which from the name you can tell is a temporary status, and that's usually about 18 months at a time. And that has just been extended and redesignated for Afghans. But parole and TPS are both temporary. So today we're talking more about people who are on a path to permanent status. And so of this group of people who have come to the US and applied for asylum, the most recent statistics are about 19 to 20,000 Afghans have pending asylum applications in the United States. And of that group, USCIS has adjudicated approximately 6,700 applications at this time. And of that group, there's been fewer than 75 denials out of that group. So we're now at a point in time where a lot of Afghans have been here for 2 years, they've applied for asylum, their asylum applications are being granted, and then the question is, what's next? And that's what we're going to talk about in today's presentation. So we can move on to the next slide, please. Before we jump into our overview of adjustment of status, I just wanted to give a quick aside that one of the most common questions that people ask at this point, once asylum has been granted for them, is how do we bring our family members over? If someone's here and they've won their asylum case and they're going to be moving forward with their attempt to become a lawful permanent resident and then a citizen in the United States, family reunification is frequently the #1 priority, trying to bring family members over. This presentation doesn't really focus on it, but I did just want to quickly raise it because you'll probably be getting those questions. That after being granted asylum, an asylee can file for their eligible family members to come to the United States using a form I-730, which is a refugee or asylee relative petition. And that form has to be submitted within 2 years of the asylee's asylum grant. They can submit the I-730 at the same time that they file for adjustment of status, which we're going to talk about now, or while that adjustment case is pending. But it's not an automatic that their family members need to come over. They need to file an additional form for that to happen. And just as a plug, ILSAA has put together a great presentation and training on family reunification. So if you need more information on that, you can reach out and we can give you those training materials as well. All right, next slide, please. So focusing on adjustment of status, what is adjustment of status? What we're talking about here is for people who have been granted asylum, they can now adjust their status from being an asylee, which means someone who has been granted asylum. They can adjust to lawful permanent resident status. And from there, down the road, they can adjust to become a US citizen. So adjustment of status is the process to apply for lawful permanent resident status. It's also known as applying for a green card. An adjustment of status, it's not specific just to asylum. For example, someone who has special immigrant visa, who SIV status, could also go through adjustment of status for their legal permanent residency. But today's training, we're focusing on adjustment of status for asylees. So you might hear us just refer to it in the asylum context. Adjustment of status is more broad than that, but today we're really just going to be focusing on what happens for asylees in the process. Next slide, please. So this slide gives you an overview, a kind of timeline of the process for Afghan asylum seekers. The first step is that they arrive in the United States. And like I mentioned, many people who have fled from Afghanistan were offered parole status, were paroled into the US through Operations Allies Refuge or Operation Allies Welcome. And those people were given parole status for 2 years when they came into the US. And now that parole is being extended for 2 more years for people who need that extension. Once they're here in the US, then they can apply for asylum. And Afghan parolees apply for affirmative asylum with USCIS. And ideally, they file within 1 year of arriving to the US, but there can be exceptions for people that need longer time than that, especially if they're parolees and they've had another legal status. And ideally, USCIS is supposed to schedule an interview within 45 days of their filing. We've been seeing a lot of delays there, but that's the ideal schedule. And they're eligible for employment authorization at that time. We're going to touch more on the different categories of employment authorization a little further in the training. Then after they've had their asylum interview, USCIS is supposed to provide a decision within 150 days of the interview. That's an expedited timeline for Afghans. Again, in practice, it's taking longer than that at this point, but that is in theory what's supposed to happen. And once asylum is granted, then someone is called an asylee. They're no longer an applicant for asylum, they're now an asylee. An asylee status is a permanent immigration status. An asylee can automatically receive employment authorization under a special category for asylees. It's the A5 category. And from USCIS, someone should receive their A5 employment authorization card with their asylum approval notice. So they've got their ability to work, they've got their asylum approval. And like I said, that is a permanent immigration status. But to keep moving down the path to becoming a US citizen, the next step is to apply for adjustment of status. And adjustment of status is available to applicants 1 year after the asylum grant. Then they are eligible for adjudication of their application to become a legal permanent resident or to obtain their green card. And so they can, the application will be adjudicated at the earliest 1 year after the asylum grant. And then if granted, if adjustment of status is granted, then the asylee changes from an asylee to a lawful permanent resident, someone who has a green card. And then after 5 years of being an LPR, of being a lawful permanent resident, someone can then apply for citizenship. And so that's really the overview of the process that we're talking about today. Next slide, please. So we're going to now get into the nitty-gritty of how to apply for adjustment of status. And the general checklist here is that you need to determine someone's eligibility for adjustment of status and determine when you can file, prepare the application, submit the application by mail, obtain a medical examination report, and prepare for an interview if needed. So this is our checklist, and now I'm going to pass it to Stacy to jump really into the details of what each of these things mean.
Thanks, Stephanie. As it's been mentioned, my name is Stacy Kim. I am a staff attorney at the ABA Commission on Immigration, and I get to work with Stephanie, and we get to partner with ILSAA. So we're just very grateful for the opportunity to speak on such an important topic and to work with ILSAA on everything that they do. So moving on with the eligibility requirements, we've listed them here, and I'll go into depth on each one just a little bit more on the following slides. So the first one is going to be physical presence, and that means, we can move on to the next slide. Thanks, Hannah. So physical presence, the physical presence requirement means that the asylee must be physically present in the United States for at least 1 year after being granted asylum. And usually the evidence required to show this eligibility requirement is pretty minimal. We'll talk about that when we go into the section about preparing the application. But the manual does specify that it must be a cumulative total period of at least 1 year of physical presence in the United States in order to apply for adjustment of status. The second eligibility requirement is that the principal asylee must continue to meet the definition of a refugee, and more importantly, that any derivative asylee continues to be the spouse or child of the principal asylee. So if you have helped a family submit an asylum application, there is a principal applicant who's usually one of the parents, and then there can be derivative applicants that is a spouse or an unmarried child under 21 years old. Some folks choose to submit their asylum applications separately, even though they can be a derivative. I've also seen some folks apply as a derivative applicant with a family member, but also submit their own as an independent asylum claim, just depending on the basis for the asylum claim or claims and the strategies used there. But what is important at this stage is that those who applied as a derivative need to demonstrate that that family relation still exists at the adjustment of status stage. And that can be shown through a marriage certificate, birth certificate, and so on. The third requirement is that the asylee is not firmly resettled in a foreign country. This is probably a bar that was discussed at the asylum application stage, but because it's an explicit eligibility requirement for adjustment of status based on asylee status, I wanted to include that in here as well. And this is mainly if a resident status was offered by a different country. And so that's a different standard than if one were to have applied. The fourth eligibility requirement is a list of inadmissibility grounds that can be either waivable, the ones in the left column here, or those that are non-waivable, and those are on the right column there. I'm not going to go into all the specifics as it can be very fact-specific, case-specific, and it would require you to go into each of these statutory provisions that you think may apply, do the analysis from there. But I just wanted to flag a few common ones. If there are any concerns of a physical or mental disorder, a drug addiction, or even not having the COVID vaccine, that can raise issues on the medical exam report, which will also go more in depth, but there are health-related inadmissibility grounds that can prevent somebody from being able to adjust status. So INA 212A1 lists more information on those. The other big bucket of inadmissibility grounds that we may see are crime-related ones, and those who have a conviction or admitted to a crime of moral turpitude or controlled substance violation may be inadmissible, although there is a petty offense and a juvenile offense exception. In addition, those with 2 or more convictions with an aggregate sentence to confinement of 5 years or more may be subject to this inadmissibility grounds. So if any of these concerns come up as you're filling out the I-485, then that's something to do the research on and strategize with how to address potential inadmissibility issues, and that too will be discussed further in this training. Okay. Next, I wanted to discuss when to file the asylum application, and the general requirement is that it's 1 year after someone is granted asylum. However, recently, earlier this year, there was clarification from USCIS on what exactly this meant, because there was confusion on whether you can submit the application before the 1 year deadline, so long as that means it's adjudicated after the 1 year requirement is up, or if you're not even able to apply until after the 1 year after receiving the asylum decision. And they clarified that it's in fact the I-45 adjudication date that must occur after the 1 year physical presence requirement. And so based on that and the USCIS case processing times, which consistently lists that these applications can take months, if you're lucky, and more likely more than a year, maybe even 2, although the timeline for Afghan asylum application or adjustment of status applications is still just based on anecdotal evidence right now. But the general recommendation is that you can submit the adjustment of status application right after receiving the asylum grant. However, I know that some practitioners are a little concerned about that because there's at least been some anecdotes swirling around that that USCIS has granted the adjustment of status application prior to the 1 year mark as a mistake, and that can lead to issues at the naturalization stage if they're not remedied at this stage. So I know some practitioners are choosing to wait at least 6 months or so before submitting the application. Others might feel more comfortable waiting until the actual 1 year mark. But in terms of what's written in the policy guidance, you are allowed to submit the adjustment of status application prior to the 1 year mark. It just wouldn't be adjudicated or correctly adjudicated until after that 1 year mark. All right, now we're going to go into what you need to prepare for the application or the application packet, as probably more correctly named. And so first it's the cover letter, and I like to just use the cover letter as a way to make sure I have everything included in the packet as it should be. And it's also a place where you can clarify anything such as what makes someone eligible for a fee waiver. You can clarify that it's an asylee-based, Afghan asylee-based application. And you can also list any arguments if needed in the cover letter as well. But we'll go into specifically the different types of forms, starting with the I-912. And the I-912 is the request for a fee waiver. And so this chart here on the right shows what the form fee is, and then what the biometrics fee is, and then what the total cost would be, depending on the client's circumstance. And something that's important to note is that if the fee waiver is rejected, then the entire application for the adjustment of status will be returned and it won't be considered filed. So in essence, you wouldn't have a place in line with that application because it wasn't correctly accepted by USCIS. Each principal and derivative asylee is required to submit a separate application with a fee or a fee waiver. And each fee waiver also requires submitting supporting documentation depending on what the basis of the fee waiver is. So that can be a means tested benefit, a household income that's below 150% of the federal poverty guidelines, or showing that you have a financial hardship. And all of the requirements for those pieces of evidence are more specifically laid out in the I-912 instructions as well. All right. Next is the meat of the application packet. This is the I-45, which is the actual application to adjust status. And part 1 to part 7 is mainly biographic and familial information. So that's something to just thoroughly go over with the applicants and make sure that information is up to date especially from the asylum application information that you may have. What could take a while is going through part 8, which lists nearly, let's say, over 80 questions hitting on various inadmissibility concerns. So if there's ever a question that your client admits to or answers yes to, then that's something to get more facts about. It might require you to obtain a police report or a court record, or just explain in the additional information part of the application. And we'll talk about different strategies for that in just a moment. One thing I wanted to note about the previous slide, sorry about that, is number 61 is that you can make sure to check that one is not subject to the public charge ground of admissibility, which means you can skip to number 69A. All right. When figuring out which evidence you should attach to the I-45, I listed the things to think about here. First is a proof of the asylum grant. So that's most likely going to be the approval notice from USCIS. And the approval notice alone is generally the only information that USCIS needs to see if one meets the 1 year physical presence mark. They'll also review the I-45 information, the address history information, and all that And should USCIS require more information to determine if the physical presence requirement is met, then at that point, they'll normally issue an RFE and request that information. In response to the RFE, you can submit additional information such as utility bills or mailings or whatnot to demonstrate continuance or to demonstrate physical presence for that 1 year. But normally the approval notice should be sufficient, at least in the initial filing, to meet that requirement. Other requirements are government issued identity document with a photograph. As I mentioned before, if it's applicable, certified police and court records to explain any charges, arrests, or convictions. And the last bullet point here is something that comes up commonly with many Afghan clients, is that there's sometimes discrepancies in one's name or one's date of birth. And in that case, it may be necessary to submit additional evidence to demonstrate the correct one. Now, at the adjustment of status stage, I would say that so long as the asylum approval notice and the A5 employment authorization document or the work permit card show the correct information, then that should be sufficient proof to have your I-45 processed with that same name and date of birth that your client wants to use. If it's different, then that might involve needing to get the Tazkira or some other government issued document that has the correct information so that you can notify USCIS about the changes that you'd like to make on this part of the process. All right, the next form is the I-693, which is the medical exam report. And this is required for all adjustment applicants. And the first step to getting this form filled out is to find a civil surgeon. And I included the website here. It's pretty Googleable as well. But there is a list of USCIS civil surgeons all across the country. And these are various physicians who I assume filled out some paperwork or met some requirements to be a civil surgeon and to complete these exams. These exams are normally pretty costly, ranging from $200 to $500, depending on the office, the vaccinations, and the tests required. So one tip I'd like to give is to consider finding a local pharmacy, such as CVS or Walgreens, that can give vaccines at a cheaper price. And your client will need to be scheduled for a medical exam with the doctor's office, and then the doctor's office will need to fill out the form I-693 and put it in a sealed, signed envelope. Now, I always like to request for the doctor's office to provide an unsealed copy of the medical exam report so that I, as the attorney, can review it and see if there's anything that wasn't completed properly administratively or something that needs to be addressed in terms of a health-based inadmissibility ground. Oh, another note, you got to make sure that everything is signed properly or else that can get bounced back by USCIS as well. If needed for a health-related admissibility ground, you can consider a form I-602, which is a waiver for that. Now, when to submit the medical exam report can be a little bit tricky and very jurisdiction dependent. I like to sort of think of it as 3 different options. You can submit the form or the report with the I-45 packet in the initial filing to begin with, or you can wait while the I-45 is pending for a few months and then submit it afterwards. Or you can wait until you're issued a request for additional evidence or an RFE and submit it at that point. Now, some considerations for this is that one, the medical exam report is only valid for 2 years from the date the civil surgeon signed it. There were some COVID-19 exceptions and extensions to this requirement, but I believe we are back to the fact that they are only valid for 2 years. Some practitioners get nervous about this because we've seen I-45s take longer than 2 years, so that by the time USCIS is ready to adjudicate the application, the medical exam may have expired at that point. And especially if the client is supposed to cover the cost for them to pay for another exam and whatever test might be needed. Again, after the 2-year mark, then that could be a big load for them. Another consideration is, I know that some practitioners might not like the idea of submitting a sealed medical exam report on its own in option 2 when the I-45 is pending, just because USCIS is not going to send you a separate receipt for the medical exam report confirming that they've received it. However, I've learned that you can call the USCIS customer service line and they can usually at least confirm something's been received by USCIS on a certain date, even though they can't confirm the contents of that submission. For the third option, in submitting it in response to an RFE, USCIS on their website has clarified many times that to avoid any unnecessary delays, they really recommend sending the medical exam report with the initial filings. But the RFE can be a nice sign of when to actually schedule the appointments and whatnot, and get the ball rolling at that point. So I think it's just something to discuss with your client, to discuss with the civil surgeon's office that you might be familiar with, and just see what the various timelines might look like for various people and see what works best for your case in specific. And next, we'll talk about the work permit application, and I will pass this off to Steph.
Great, thank you, Stacy. So the work permit application is a Form I-765, which is the application for employment authorization. Afghan asylees should receive, when their asylum is granted, they should receive an employment authorization under category A5 for asylees. And that should happen automatically when their asylum is granted by USCIS. And there have been very recent changes to the duration of certain employment authorization eligibility, and A5 category is a 5-year eligibility right now. So that's great. So they should automatically receive that. It's also possible that Afghans who we're working with in this situation also have an EAD under category C11, which is based on their parole. And if their parole has been automatically extended while their asylum application was pending, then their employment authorization would also be automatically extended. They should receive the Form I-797C, which is a receipt notice indicating that their parole was extended and that their EAD is also automatically extended for another 2 years. So with those documents, most applicants won't need to apply for a different form of employment authorization. But technically it is possible to also apply for a EAD under category C9 while applying for the adjustment of status. But that's not really, it shouldn't really be needed because most people will already have employment authorization that's going to last for a long enough time to get them through this process, that it's probably not necessary for most applicants or most clients that we're working with in this situation. Go ahead to the next slide, please. There's also a waiver of inadmissibility grounds that Stacy went over a little bit earlier in the presentation, the different potential inadmissibility grounds that can prevent someone from being able to adjust status. But there is a waiver that can be attached if needed. And in the waiver, basically, the applicant would need to explain why they might be inadmissible to adjust status, and then also explain their reason for a waiver of that inadmissibility ground. And the 3 reasons for waiver can be humanitarian reasons, family unity, or public interest. Humanitarian might be health reasons, like they wouldn't be able to get proper medical care if they're if they're not able to adjust status. Family unity, if there's family members here, and public interest as well, if they can argue why it's for the public good that they should be here. And really, this is a very case-dependent analysis for what reason should be chosen and what facts should be included in the waiver. But basically, this is where you're trying to tug at the heartstrings, and so you really want to include a lot of information that would be compelling information for why your client should be allowed to adjust status. And now we can go to the next slide, please, about submitting the application. The application should be submitted by mail. There is no online filing currently for the I-485. So where you send it depends on state of residence. And the link here would take you to the USCIS lockbox locations that you would need to look at to see where you should be sending your client's I-485 depending on residence. It's also really important that you follow the I-485 instructions very carefully. And this goes for all forms. There are instructions that are a separate document for each form, and it's really important to read through those, understand those, and follow those. But one thing I'll highlight here is that you need to be sure to include passport photos with this application, 2x2-inch photos. There are plenty of apps these days where you can do it on your phone and get the requisite sizing, so your client doesn't necessarily need to go to a drugstore to get professional passport photos done, but it needs to be a 2x2 photo. And we always suggest that you write your client's name and A number on the back of those photos, just in case they get lost. And then also to put them in a baggie and staple the baggie to the application, or somehow affix it in that way so that it really is attached to the application. Next slide, please. In some instances, there might be an interview, and the interview would be typically required if an officer is not able to confirm an identity, a family relationship, or to a principal applicant, or admissibility based on the immigration records that are available. There's a full list of interview criteria linked in this slide for the USCIS policy manual on this topic. Really to keep in mind here is for clients who had potential trig or persecutor bar concerns when they were applying for asylum. This is something that practitioners are a little bit cautious or concerned that even once asylum has been granted and those issues have been overcome at the asylum stage, that they might come up again at the adjustment stage. So it's good to keep those things in mind. Attorneys can accompany their clients to these interviews, and it's likely that if you do have an interview request, you'll kind of know what the issue is based on your client's specific facts for the most part. And it would be important to prepare your client for, similarly as you would prepare them for the asylum interview, prepare them to how to answer their questions, and you'll be keyed in that it's going to be what issue it would be on based on the potential concerning facts in your client's case. So you can really focus on those issues when you're preparing your client for the interview. And one other thing that almost goes without saying, but it's still worth saying, is that you need to make sure that your address is up to date. Either you as a lawyer, or if you're helping someone pro se, that their address is up to date, because the interview notices will be mailed, and it's really important that we don't miss any of the important paperwork that might be mailed throughout this stage. Next slide, please. After submitting the application, the next steps are that you should receive a receipt notice by mail, or your client should receive a receipt notice by mail. There might be a biometrics appointment scheduled if necessary. And then you'll need to make plans to obtain the form I-693 as needed, and respond to any RFEs as needed if those come up. There is no requirement for expediting Afghan asylum-based adjustment applications, and case processing times are currently at 30 months, but we are finding that the process is much faster for Afghans. It has been moving much faster than the average case processing time. But you can check the case processing times to see general statuses. You can check USCIS case status online to try and find more specific information. And if things are moving really slow, you can always submit a case inquiry or a CIS ombudsman request, or a congressional inquiry, same as you would to expedite another asylum application or something else that's pending before USCIS. Next slide, please. If the decision is a denial, then you can consider appealing the decision to the USCIS Administrative Appeals Office. And the form to do that is a Form I-290, which is a notice of appeal. And you will have 33 days to do that after you receive a negative decision. And that's just because the decision should be mailed to you. And so it's 30 days plus an additional 3 days for mailing. So you'll have 33 days from the date of the decision to file an appeal. You could also consider submitting a motion to reopen or review a decision if there's new facts, or a motion to consider if you believe that the law was applied incorrectly to your case. There could be a possible referral to immigration court, or you could evaluate your client's eligibility for other forms of relief and see if there's a different route that you could try to apply for relief for your client. Next slide, please. If your application is approved, then that's fantastic news. That's what we're hoping for. You or your client should receive the lawful permanent resident card in the mail, either with or very soon after the approval notice is received. It's a really important card. Keep it in a safe place. Replacing it can take months to years if needed. So really, it's, that's guard that card carefully and don't want to lose it. And your client can apply for an unrestricted Social Security card if they haven't already done so. They can apply for the unrestricted Social Security card as an asylee. Sometimes in practice, we found that people have trouble depending on who they're dealing with in the Social Security office. So once they have their approved adjustment of status, then they definitely can do it. But they should be able to do it earlier. But if they haven't done it before, then they can do that. And their Social Security card will be unrestricted. An important point here is we recommend that your client should not travel, your client should not travel to the country of persecution until they become a citizen. Your client may travel to other countries with proper documents and if they're not gone for over 180 days, but your client should not use a passport from their country of persecution. That would be considered availing themselves to the protection of the government that they are saying that they need to flee from. So they should never travel using the passport from their country of persecution. If they do need to travel, they should submit a Form I-131, which is an application for travel document to obtain their travel permission. And I know I saw a question in the chat that came in earlier that I'll just address here. That was a question about what about an asylee as they're waiting for the adjustment of status process to go forward, what's the law or recommendations about them traveling? And, I would say the same thing here. Personally, for me, I always like to be on the safe side and I tell my clients not to travel. Just don't do it. Don't risk it, unless, and if there is a situation where they need to travel, then obviously they need to come talk to me first and we'll evaluate how necessary it is and what the process would be. But as we mentioned here, they should not be traveling using the passport from their country of persecution. So that, again, they would need to file a Form I-131 application for travel document. Even after a decision, after an approval decision, certain convictions can still deem a lawful permanent resident removable from the United States. So it's always important to give that warning to your clients as well. And they should consult an immigration lawyer immediately if they're arrested or if they have any run-ins with the law. And then after 5 years, they can move forward and apply for citizenship. All right, next slide, please. So we're going to jump in now to some common scenarios that can come up, and we will ask for your comments you can either raise your hand and we'll take you off mute, or you can enter some comments in the chat to give your answers and your thoughts on some of these questions. Okay, so the first scenario here is that your client's asylum application was approved by USCIS on June 6th. So when should you begin working on the adjustment of status application? And when is your client eligible to adjust status? We'll see if anyone wants to answer these questions in the chat, or if you want to take yourself off mute and give your thoughts on when you should begin working on the application.
Looks like there's a couple in the chat. Anybody want to come off mute and speak? Feel free.
Yep, so we're seeing a couple, the main answers coming through are that people are saying after 1 year, so apply on June 6th, and other people are saying, you can apply immediately, and some people are saying, before, just anytime before June 24th. So we'll talk about all of those different options. Our recommendation would be to start working on it immediately, that you can submit the application before 1 year. And that's kind of a change to the rule. And as I think Stacy mentioned on a previous slide, the application will not be adjudicated until 1 year after asylum has been granted. So in this case, USCIS cannot affirm or cannot grant adjustment of status until June 6th of 2024. But you are now able to submit your application before that. So you could submit it immediately. You could start working on it right away and submit that application, and it would go through the processing times. And if, for example, let's say it's processed and ready to go by April 6th of 2024, you wouldn't receive, USCIS should sit on it and wait until we get to June 6th before actually approving the adjustment and finalizing it. But you can submit the application now. So some people are asking, what's the point in submitting it earlier if it won't be adjudicated either way? It speeds up the processing time. You're just in the queue a little bit sooner, so that the processing times can be really delayed based on when you file. So it's something that you can get the process started, and then you can, as long as your applicant has been in the country for 1 year, then you can get the process started, and you can hope that it expedites things for your client. Now, I think Stacy mentioned this earlier, there has been some conversation about delaying a little bit because people are worried that if USCIS makes a mistake and adjudicates it before 1 year, then that could present problems down the road at the naturalization stage when adjusting to become a citizen because it was improperly adjudicated now. So some people are saying, let's wait a few months, maybe wait 6 months before starting the process so that you can be sure nothing gets moved forward further before 1 year. So, that's something to keep in mind, that, anecdotally what we've been hearing, but I actually, haven't really heard of that being an issue. And what should happen is that USCIS should wait to actually finalize the application if for some reason it's processed sooner. So go ahead now to the next scenario, please. So scenario 2 is about the medical exam report. We've got client B's asylum application was approved on June 6th, and their adjustment of status is ready to be submitted, but they haven't made an appointment with a civil surgeon yet. So what should you do next in this situation? I see, wait for an RFE. And that's generally what we would do is submit the form. Yep, exactly. Submit the form and wait for an RFE. We would go ahead and submit. Now the options here are that you could, what we would do is submit the I-485 immediately, as soon as possible, and then wait for an RFE to do the medical exam. You could also preemptively supplement with, before you receive an RFE, you could preemptively supplement with the medical exam. But in that situation, you might not receive confirmation that it's been received by USCIS. So you can always wait for the RFE, especially if you have a relationship with a civil surgeon and you know how long it takes for them to turn around that medical exam. If your office has worked with a civil surgeon before, then okay, once the RFE comes, this is approximately how long it'll take to get the exam, and then you can send it in and everything will be completed in the right amount of time. All right, I'm gonna pass it over to Stacy now for the next 2 scenarios.
One note about medical exam reports before we move on is that in my previous organization, we were calling various civil surgeon offices that were local just to compare costs and appointment times and all that. And a lot of the doctor's offices weren't really sure what a civil surgeon was, and they thought it was someone who practices surgery. And so we found that saying a doctor who completes the immigration exams or the immigration medical reports or something like that can be a little more helpful in obtaining information from the doctor's office directly. Now for scenario 3 about work permits, I've been keeping an eye out on the chat, even though it's been moving fast. And a couple of notes I wanted to make is that I've personally been so back and forth between A5s and C9s and all the different categories. Those who included this in the chat are correct that even if you have a pending adjustment of status application, the USCIS instructions for the Form I-485 do say that they would want an A5 work permit application to be submitted, not a C9. So I know we flip-flopped on the slides a lot, Stephanie, so I apologize for my mistake there.
That's right, thank you for clarifying.
Another note is that someone also put in the chat here the announcement from yesterday that USCIS has announced that they're extending the maximum validity of work permit cards to be 5 years instead of 2 years now. I'm not sure if that applies to those that already have work permit or employment authorization, or if that's only moving forward for those who apply. So if anyone has anything to chime in about that, please feel free to include that in the chat. So yes, I wanted to point out those two things before I go on to this hypothetical here. So this one says, Client C's asylum application has not yet been approved by USCIS. Client C has an EAD under category C8 that, let's just say, because the announcement only came out yesterday, let's just say that it's still expired on August 2nd, 2023. The questions are: 1, what should Client C do to obtain a work authorization for under category C8? And 2, what other options might Client C have? Okay, the new policy applies to EADs issued on or after September 27th. And so this hypo should remain as is. All right. Okay. So yes, for number 1, because the asylum application has not yet been approved, the client is still eligible for a C8 application. However, because the expiration date has passed, they are not eligible to submit a renewal application that would allow them to have an extension, 180-day extension on the card. If they had applied for the renewal application before August 2nd, 2023, then the receipt notice and the expired work permit would be sufficient proof that there's an 180-day extension on the initial EAD. You can submit the renewal application even after the expiration date. It just may take months, in which case the asylum application might be approved by then, but it might be one option for the client. Number 2, what other options does the client have? I see some people speaking on it in the chat, but because they're not eligible for the 180-day extension of their EAD, then that's no worries, because once the asylum application gets approved, and then they will be automatically eligible for the A5. I know some folks were saying that they received the A5 directly in the mail, others haven't and need to submit the I-765 under category A5. So it I guess just depends on what USCIS is doing that day and requires different follow-up as needed. Another option is those who have applied for OAR parolees who have applied for asylum and they're parole, but yes, they're OAR parolee. They should be eligible for the automatic parole extension process, which means they should be automatically receiving a receipt notice of an automatic extension of any C11 EAD they may have. And this would be sufficient proof of employment authorization for 90 days. And then at that point, the client can submit an I-765 for a new EAD card under category 11. I know we went through that really fast, but we wanted to leave some time for Q&A. And so I think we'll just jump straight into that, if that's okay with you, Steph.
Yeah, that sounds good. And I have, I just want to let folks know we have a lot of questions in the chat. We won't have time for all of them today. I have copied them down and we will publish the questions and answers after today's session. I think we have time for one question. And I will call on a couple of folks who have had their hand up. Charlotte English, I think you've had your hand up for quite a while. I'll go ahead and call on you if you want to come off mute and ask your question. that would be great.
Okay, thank you. My question on the medical exam, on the 693's instructions, on the updated 693 from, I think, February, under the frequently asked questions, there is a number 5, which specifically talks about Afghan nationals who entered the US under OAW. And it says they're trying to adjust status. And it says if they had an overseas medical exam completed by a panel physician, and they did not report a Class A medical condition, it says they do not have to do the full 693 medical as long as it was done no more than 4 years before the date they filed to adjust. So I just wanted clarification on that, because I think that is significant, especially considering the cost of the medical exams if they're not needed. So I just wanted input on that. I've been navigating that under question 2 for refugees actually recently too. So I just wanted your thoughts on that.
I can take this stuff. Thanks for pointing that out. I'm not sure what the process is for USCIS or Department of State or whichever agency is really in charge of the immigration and medical examinations that are completed abroad. I guess those who are I guess in the dark of getting those results and checking for that. I guess the safest option is to just submit the form I-693. But yeah, especially if there are cost concerns and other time delays concerns with that. I guess that's something to follow up with either USCIS or your client to see where you can confirm that a Class A medical condition wasn't reported, as well as just getting some sort of documentation of the medical exam. I know I've heard a lot of anecdotes of, oh, I got this exam done in Qatar before coming to the US or whatnot, but I haven't personally seen any paper documentation. So if anyone has, please chime in the chat. But sorry, I don't have more concrete information on that, but we will look into it and include that in the written Q&A responses as we're able to.
Thank you, Stacy. And we have just a few minutes left, and there's a couple other things we want to do. So thank you for the questions. If you had your hand up and didn't have time to write your question down, please write it in the chat so we can make sure we get back to you. And let me let you talk about this upcoming webinar, Stacy or Stephanie. I'm sure which one of you is covering this.
Great. Yeah, I'll just jump in really quick to let you know that the Commission on Immigration is hosting a webinar on October 11th that covers common obstacles when representing Afghans. And this is going to cover things like TRIG, the persecutor bar, firm resettlement, other common issues that you might see when representing representing Afghans in asylum cases and also in other different types of cases. So the registration link is here in the slides, and you'll be getting a copy of these slides. And also here is, I'm just putting in the chat. Oops. Well, I will put in the chat in just a second that the link for the practice advisory. We have a written guide that covers these issues as well. So I'll put the correct link in the chat here. It automatically shortened it. So you can all download that as well. And we hope to see you at this next training. Thanks, Becky.
Sure thing. And then lastly, oh, you got it in there, Stephanie. Great. Let me, yeah. The last thing I want to just give Bridget Ott. Bridget, are you still with us on the phone? I've seen a couple of questions in the chat about how do I ask more questions. I wanted to share information about how to join ILSAA as one of our legal service providers in case you would like to do that. So Bridget, I'll let you speak.
Thanks, Becky. Hi, everyone. My name is Bridget Ott, and I'm ILSAA's partnership coordinator. So we at ILSAA here are still actively recruiting legal service providers to join the ILSAA network. There are many benefits of joining, including receiving reimbursements for the ILSAA cases that you take. So essentially, ILSAA may pay you for the immigration services that you're going to provide anyway, including for any clients that you have that are on a wait list and that you register as ILSAA cases. Other benefits of joining include access to additional training, webinars, a resource catalog, and access to our peer networking hub, which allows LSPs to share best practices and lessons learned, as well as ask questions of each other about Afghan cases. If you are already ready to join, you can just email ilsainfo@icf.com. I'll put that in the chat with the subject line, joining the LSP network. We will respond back to you, and our registration coordinators will reach out with some next steps. And if you just want more information, you can reach out to me. I'll put my email in the chat as well, and we can schedule a call and speak further. Thank you.
Thanks so much, Bridget. I appreciate it. And yes, you will get a copy of this presentation emailed to you after the presentation. I see a couple of questions about that in the chat. Lastly, thanks, Bridget, there's your email. And lastly, there are some resources that we have called out at the end of this session. I'm not sure if you have that slide available, Hannah, but just know that we have some additional recommended resources for you to look at. They'll be attached at the end of this deck. And with that, it's 2 o'clock. Go ahead and throw the evaluation link. Thank you, Hannah, in the chat. If you could take 1 minute and do that, we would much appreciate it. And thank you all for joining. And you can look out for information in the next week or so about our next webinar. Thank you so much.
Thank you, everyone. We really appreciate the robust comments and questions in the chat. And like Becky said, we'll put together a written document to send out as well, addressing the questions we couldn't get to today. Thanks so much for joining us.